But everything I've seen, the biggest issue in the Obama case, I think, was this Hawaii birth certificate. But I think I've read enough now to at least satisfy myself that it seems to be that all of these challenges are politically motivated sour grapes. But I mean that's the substance of it. We're talking about the mechanics of challenging, and I don't think there's anything per se barring such a challenge.
Yeah, certainly our lawyers have looked at it and decided to fry the fish. I open the floor up to questions. I don't know if we have a microphone we're supposed to use. I think we do. Are there any questions or concerns that we haven't addressed yet?
Just one question. When you were talking about the escape clauses that had been written into other amendments, those amendments, though, came after this, the Article 1 Emoluments clause. Do you think that has any bearing on whether or not the lack of an escape clause being relevant?
The first example I mentioned is actually a different part of Article 1. The second one is from the 14th Amendment, but I don't think that makes a difference. I mean, all of the Constitution is equally valid once it's ratified.
Any other questions? Jim?
I had a question concerning whether maybe the Saxby fix is adequate. As I understand, the bill is reducing the salary to January 1, 2007, correct? And the provision, the Constitution limits eligibility to senators or representatives during the time for which they were elected. Now, because Senator Clinton was elected before January 1, 2007, do you think an argument could be made that that's...
It's for the term for which they were elected. So the term starts January 3rd, 2007, her current term.
Is it clearly that term, though? Is that supported?
The clause uses the word during the time for which he is elected. I think that the best reading of that is that it relates to the current term and is not a lifetime, as long as you've been in Congress, situation.
Okay.
Talk a little bit more before we close. I'd like to learn a little bit more about the Reagan example. I first read about this clause, I'm ashamed to say, because I read about it in the Washington Post. And in researching a little bit further, I talked to a reporter, and I was inquiring about the Reagan issue, and the reporter said, "Oh yeah, I got that one mixed," because I guess there was an inquiry made to Orrin Hatch's office when his name came up about the Emoluments clause, and it caught the attention of, I guess, the administration, or so the reporter would imply. Is the opinion out there publicly available, or is it just received? Is it a mythology? Is it just assumed that that's what happened, or what's the fact behind it in terms of the information that's available?
My understanding is that the Office of Legal Counsel opinion at issue has not been released, or at least it wasn't when I wrote my article 13 years ago. It's numerous people with firsthand knowledge have confirmed that it exists and that it was issued regarding a potential nomination of Senator Hatch. Interestingly, I guess a couple of years ago, there was a book written about the Supreme Court where the premise was offered that the Emoluments Clause issue that put the kibosh on Senator Hatch was actually something that the Reagan administration cooked up because they didn't really want to nominate him. And I don't know if that's true, but I do know that the position of the administration back at the time was we can't do it. It just doesn't really matter.
Do you have any thoughts on that?
Nothing to add to that.
Well, unless there are any other questions, we'll close. We do have another question.
Yeah, I want to follow up on what you brought up, Tom, about the, we'll call it the Obama Relief from the Constitution Act, because some of this, it's quite amazing. As you said before, someone 33 years old can't run for president, but if there's no mechanism to require him to prove that he's 35, and that's what's apparently happening here, because I think this certificate of live birth that he posted on his website has really been shown to be a fraud. I mean, a fraudulent document, and he refuses to allow his birth certificate to be seen. And so it's kind of odd that there is no mechanism in the Constitution that requires someone to prove that they are eligible, just the two measures of eligibility, age and being a natural-born citizen. For instance, in this one of the cases, this D'Onofrio in New Jersey basically went after all three to prove, because the guy from the Green Party was born in Nicaragua and is a green card, holder, and that's obviously not eligible. But he was allowed to be on the ballot because there really is no mechanism to keep him off. And so,
well, one of the courts ruled that the clause had no enforcement mechanism, so it was up to the political system to figure it out. And you're suggesting, assuming that they're standing, that that's probably not correct. I mean, I think the problem with the cases that have been brought forward is that they really haven't stated, from a non-legal perspective, I know enough about what you need to do to get into court and stay in court. They haven't done enough to stay in court, but the courts seem to have taken the position, or at least one lower court took the position that it's not our ball. It's the political system's ball.
I'll offer the caveat, as Ilya said earlier, I've not researched this issue and I don't claim to be an expert. I did read recently that back in, I think it was the 60s, or it was either 68 or 72, that at least some courts had intervened and struck, I think it was Eldridge Cleaver, from ballots because he was not 35. So I think, without having seen the firsthand documents, I've read that there are instances where courts have intervened when someone is not eligible to remove them from the ballot.
Okay. One more question.
Can you talk a little bit about the actual procedure, the mechanism of this joint resolution, why that device is used over others, or Ilya mentioned in general, I guess, the circumstances of a fast 2-minute uncontested kind of voice vote to pass the resolution
That
itself.
was in the House.
Yeah. Can you kind of put a little more framework around that? Well, the actual technical procedure, the joint resolution itself, why that device and how it's being used.
Well, you can look on Thomas online and search SJ Res 46, and here's what you'll get on 12/10/2008. Introduced in the Senate, read twice, considered, read the third time, and passed without amendment by unanimous consent. Also 12/10/2008, message on Senate action sent to the House. 12/10/2008, 8:45 p.m., received in the House. 12/10/2008, 8:55 p.m., Mr. Davis of Illinois asked unanimous consent to take from the Speaker's table and consider. 8:56 p.m., considered by unanimous consent. 8:58 p.m., on passage, passed without objection. 8:58 p.m., motion to reconsider laid on the table, agreed to without objection. 12/10/2008, without a timestamp, cleared for White House. 12/12/2008, presented to President.
And it doesn't indicate it's been signed yet?
I have a feeling that he's waiting for Senator Clinton's confirmation hearings or something like that, because as a favor to her or whatever else, or to the next Secretary of State, whoever it is, if for some reason she's voted down, I guess President Bush doesn't want whoever it would be to have that lower salary, because in these times the extra $5,000 really goes a long way.
Well, I appreciate it, John and Ilya. It's very educational, and I just hope more people pay attention to this issue. Obviously, it's no secret that we're figuring out ways to challenge this, and I'm going to be unapologetic, and I think there are other reasons to prevent her from being on the Supreme Court that go to the merits of her appointment. But this issue is not really about that. It goes to her eligibility in the first instance in terms of the Constitution. And it's similar for Mr. Salazar as well. And Lord knows we would have sued LaHood or over LaHood if we could.
Don't sue LaHood.
Right, over LaHood if we could. But it looks like we won't have